Good evening, class. Online class is daily working. Online class. Okay. So, good evening, class. Let's start with today's current affairs with regard to polity and current affairs. Okay. So, polity and governance ka current affairs pe the topics that we will be discussing is building Vikshit Bharat through empowered panchayats. Supreme Court declares right to walk as a fundamental right. Center tightens FCRA rules for NGOs receiving foreign funds. Passport is a travel document and not a proof of citizenship. Last topic is criminalization of politics in India. Understood? Online class. So these are the topics that we will be discussing for the day. The first thing, building Vikshit Bharat through empowered panchayats. Now look at this. Why first we are discussing this topic means your Ministry of Panchayat has given the last 12 years, okay, of data as to how much your panchayats have reformed, that is changes have been brought to them. Okay, so in the last 12 years if you see, India's progress has been largely made with respect to Panchayat Raj institution, which has led to building a more of self-government institution, which is the ideal of your Vikshit Bharat or developed India by 2047. Okay, so the development, if you see, it is coming from financial accountability, and also your Ministry of Panchayat Raj has taken so many initiatives to make sure that your Panchayat Raj institutions will function as self-serving units or self-sustaining units. In otherwise, in the federalist, center, state and Panchayat Raj institutions all have the underlying thing of democratic decentralization. Understanding? Now, so in this we will be seeing what are the reforms that that has been brought about in your Panchayat Raj institutions. Your 73rd constitutional amendment which created Panchayat Raj institutions, under which 11 let's say your 29 subjects has been brought under your Panchayat Raj institution with respect to 11th schedule, and municipalities is your 12th schedule, 74th constitutional amendment, and more than 2.59 lakhs of gram panchayats has been digitized. Does it mean everything is good, everything is happening very well with Panchayat Raj institutions? No, there are equal amount of challenges also. We will see that too. Now, again, why is it in news? Because Ministry of Panchayat Raj has given the information of the last 12 years of the functioning of Panchayat Raj institutions, and the reforms are closely associated with reaching India's target of Vikshit Bharat 2047. If you see the constitutional basis, your Panchayat Raj institution was constitutionalized in your 73rd Constitutional Amendment Act, where Part 9 was added into the Constitution from Article 243 to 243O, where a new schedule of 11th schedule was created with 29 subjects, and this transformed 2-tier country into 3-tier country. What is the 3-tier country? Center, state and Panchayat Raj institutions. These Panchayat Raj institutions will have Panchayat and municipality. Okay, this is how it is seen. Next, if you see with respect to your fiscal devolution, see, first and foremost, one of the major issues or complaints, if you see what is it plaguing your Panchayat Raj or your Gram Sabhas and Gram Panchayat are not developing at a full potential is because of one main thing: funding. So majority of the time we have created provisions of own tax sources or own revenue sources. But previously I told you, remember 11th schedule has 29 subjects. Most of the states, the 29 subjects has not been completely transferred itself. Okay, first thing. Second thing is, the money that they are getting from the own source revenue is very less negligible compared to the money that they get from your devolution of funds. Devolution of funds means something that is given or recommended by the Finance Commission to the center and State Finance Commission to the state to give money to the Panchayat Raj institutions. So they are constantly relying on these institutions for their income generation or money. So if you say 15th Finance Commission had told that 2.82 lakh crore rupees will be allocated, out of which 94.98% of funds were released. Now the same thing if you see for 16th Finance Commission, they increased, do you see a substantial increase from 2.82 lakh crores to 4.35 lakh crores. This is the recommended amount. So it's a significant 84% increase. Understanding? Now if you remember I spoke about your own source revenue. That is somehow that they try to generate their revenue without having to rely on any other institutions. Further, they have created this Samarth Panchayat portal, Atmanirbhar Panchayat program. What this is further down we will see. What is the overview of this means? For revenue assessment, tax demand generation, digital tax collection, and this is the most important thing, reduced grant dependency. Okay, so this is what they are trying to do. Next, another important component under this is your capacity building program. Otherwise, Rashtriya Gram Swaraj Abhiyan, which was revamped in your 2022-23. What is this Rashtriya Gram Swaraj Abhiyan? In simpler sense, see, the whole point of democratic decentralization is to make sure that people participation, awareness, and also most importantly, you train them as to what can they expect from this, what can they deliver from this. Okay, so under Rashtriya Gram Swaraj Abhiyan, more than 4.10 crore elected representatives and functionaries have been trained, and the most important thing is 33.5 lakh women representatives are trained. So you know, under your Panchayat Raj institution there is an obligation for 33% reservation for women. But most of the time, what is the issue we will encounter with this reservation? See, is this good? It is very good. But is it realizing its potential? No. Why? See, most of the time the issues we see is Sarpanchpati. Okay. So, where male members dominate or use the women just in the name of reservation as a rubber stamp. Okay, so this is not something that is very much bringing the potential. So here with the women representatives being trained is one step towards your capacity building. Okay, so what areas are these people trained in? Good governance, leadership, service delivery, and financial management. Alongside this, it has also been, the review has also spoken about your tribal empowerment and inclusive leadership, especially under your PISA Act. So your PISA Act was brought in as to see India has a varied amount of cultural interests and pockets. When we wanted to create uniformity with Panchayat Raj institutions, we wanted to do two things. See, we wanted to create uniformity of Panchayat Raj institution throughout India. But for 5th and 6th schedule areas, we have promised tribal autonomy. So the balance between uniformity and tribal autonomy is what came in the form of PISA Act, Panchayat Raj Extension Act to your schedule areas. So now based on your Buria Committee report, that is in 1995. So what are we trying to introduce from your Panchayat Raj institutions? Means first and foremost, self-governance in the 5th schedule areas, and you will empower the Gram Sabhas to be more of a right-based claimants. And also bring awareness towards your participative democracy. And also protect the tribal traditions. You will do one without compromising the other. So because of that, they have created PISA GPDP portal, which means you try to make sure that the translation is available. Now, for example, let's say if you are going to create these things, and most of the issue or your digital content is available only in two mediums, Hindi or English, that becomes a issue. So what happens here is you create indigenous language manuals, understanding, so that is easily understandable. So another aspect is, look at this, Sashakt Panchayat Netri Abhiyan, again specifically targeted at your female representatives, which is again 33% of mandation is there, whereas in certain states like Karnataka and Bihar, they have kept it for 50% also. Okay, so you give them leadership training, governance skills, and give them your decision making capacity, and not turn them into rubber stamps or your corporate patis or sarpanch pati syndromes. Now if you see with respect to youth, okay, being associated to your panchayats, they started Model Youth Gram Sabha. It is very much closely aligned with your National Education Policy of 2020, where you bring in to make sure that there is good amount of awareness and also the participation is there in making sure that grassroots level leadership development is built from very young age. So much so that in your, if you see the recent NCRTs also, they're trying to actively promote these concepts. Understanding? So if you see, another most important aspect of what has reformed in this 12 years, which is given by your Ministry of Panchayat Raj, means it is digital governance or e-Gram Swaraj portal. Meaning more than 2.59 lakh Gram Panchayats are digitized with respect to planning, budgeting, accounting, asset management. So this creates a real-time monitoring of data, transparency, okay? And with respect to your public finance management also, it is fully integrated, and your digital transactions are more of encouraged, okay? Now, they've started the new AI-based governance and technology innovations. One is your Sabasar platform. See, or usually in corporate and all, you have minutes meeting. That is more like a summation of what happened in the meeting. So similarly, on the same concept, what happened today in the Gram Panchayat or Gram Sabha, okay, that minutes will be generated by your AI of the Gram Sabha, Gram Panchayat functioning, and also this will be available in multiple languages. Again, I told you one of the issue is because the content is available usually in English or Hindi only. Okay, in this case, online class, any doubts? Okay. So in this case, Bhashini app, which will give the translations in multiple regional languages, and this gives the summarization and transcript for what has happened. So this will help the youth, rural youth also look into this, again integrated with your NEP 2020. Next is your Panchayat Advancement Index. This is more like, see, you have heard about your SDG, Sustainable Development Goals. Now the same thing when what are some of the SDGs? Poverty should be reduced, hunger should be reduced, education for all these aspects. No, now that when it is brought down to India's level, then we call it as localized SDGs, which will be able to measure the performance metrics. Okay, so this is one new advancement. Then other things are hyper local weather forecasting with respect to let's say you have tagged up with your Indian Meteorological Department to forecast and help with respect to your crop planning, and Meri Panchayat app, okay, again in rural areas for your awareness to create as to what is the public assets, how much is the funds coming, how much is the funds used. Okay, it's more of an app which has 1 crore plus downloads. So if you see what are the main issues, it is 3 F's: funds, functions, functionaries. When you see with respect to funds, they are heavily dependent on grants from your central or state government. They have very less fiscal autonomy. RBI in a 2024 report has pointed out the own source revenue generated in the panchayat amounts to less than 1.1%, and 95% of the funds is coming through the devolution, that is through center or state government. Next, functions. Like I told you earlier only, when we had 11th schedule, the 11th schedule has 29 subjects which still has not been transferred completely. And also your election delays constantly that we see, okay, will further create a lot of vacancy backlogs. And another functionaries issue is there is lack of shortages of staff, like no independent auditing, and also the lack of accountants, bureaucratic dependence is heavier. So this creates a capacity building to be very much dependent on the organizations. So what are other challenges that we have? If you see, like we discussed, proxy representation in the form of sarpanch pati, women representatives are often just used as a face or a facade cover. Then weak Gram Sabha participation because of caste division, gender bias, poor attendance, and also low awareness. Youth participation is also less. State Finance Commission, if you see, they are very much delayed in constituting the Finance Commission, and whatever recommendations given by State Finance Commission are not binding on the government. Okay, so this further creates a difficulty for the devolution of funds. Now, we'll see one possible question. With reference to recent initiatives for strengthening Panchayat Raj institution, consider the following statements. Panchayat Advancement Index measures Panchayat performance based on themes of localized sustainable development goals. This is correct. We discussed this, like poverty, hunger, and those things. Sabha Sar uses artificial intelligence to generate Gram Sabha minutes of meeting in multiple Indian languages. Yes, it generates your meetings in AI generated through your translation of Bhashini app. This is also correct. Gram Manchitra is a digital platform primarily designed for collecting panchayat taxes and own source revenue. No, it is not for collecting taxes, it is just for geospatial data. So this is wrong. Correct options are 1 and 2 only. The next topic we will be looking into is Supreme Court declares a right to walk as a fundamental right. Now, what is this right to walk as a fundamental right? Before venturing into this, let me tell you an incident. A father, along with his 5-year-old son, was going to drop the child to the school. But a vehicle came, crushed the child, and the child succumbed to the injuries. This was such a heartbreaking thing as to, if you see the Motor Vehicles Act, on the roads, the primary element is considered as the vehicles and not as human beings. When you don't have the ability to walk freely, because freedom of movement is your fundamental right, then what exactly are you giving to the people? This is what led to Supreme Court taking up and tell that right to walk is a fundamental right, which means the right to safe pavements, footpaths are very, very important. Your motor vehicles should not be the primary thing here. It is the individual or human being walking on the road that becomes the important element. Okay. So this was held in Maniyar Ilyas at Sheikh Riaz versus P. Ayyappan and others case. Okay. And also alarming amount of data is in if you see from your 2000s to 2020s, there has been alarmingly 163% rise of your pedestrian deaths and 20.606% of contribution to the road accidents is because of this pedestrians, lack of access to safe footpaths. And according to Article 19, freedom of movement, and Article 21, right to life and personal liberty, your right to movement is getting violated here. So, why are we discussing this? Maniyar Ilyas case, Supreme Court declared a right to walk on safe demarcated footpaths as a fundamental right. So, this strengthens your pedestrian rights, urban governance, and constitutional reforms. So, by 2015 to 2024, there has been 163% of increase in pedestrian deaths. 2015, the total road fatalities caused by pedestrian death was 9.5%, means by 2024 it has increased to 20.61%. So this indicates there is a huge amount of road safety concerns that is there. So if you see the constitutional aspects or legal framework behind it, Article 19(1) of the right to move freely throughout territory of India. Article 19(1) of A, freedom of speech and expression, and even movement is a form of expression. 19(1) of B, right to assemble peacefully and then from there travel. 19(1) of C, right to form associations, people coming out in public. Article 21, right to life and personal liberty. So, what Supreme Court has held in this means, right to walk is a fundamental right because walking is essential if you have to express your right to freedom. And also pedestrians should have priority in the roads and not motor vehicles. Public spaces should not be monopolized by the motor vehicles, and vehicle movement comes secondary. The primary thing is your pedestrian safety. So Supreme Court has also told that state has to make sure that its urban development authorities with respect to municipal corporation, municipalities, panchayat, everyone are to function to make sure they demarcate footpaths, construct footpaths, maintain safe walkways and ensure pedestrian safety. So no one can escape from this. At the same point of time, your judiciary has told citizens can seek legal remedies if the authorities fail to provide safe footpaths, proper maintenance of footpath and pedestrian infrastructure. Not just constitutional, but also you can file under your legal rights. Alongside that, you also can claim under your Motor Vehicle Act. Motor Vehicle Act of 1988 was also criticized by a judiciary because the entire law is treating the motor vehicles as the primary aspect and your human beings as secondary. So this is not good because it is a vehicle centric legislation and not human being centric legislation. So they are telling that you have to create a pedestrian centric legal framework. Okay, we'll see a possible prelims question. Consider the following statements regarding the Supreme Court judgment on the right to walk. The Supreme Court held that right to walk is a part of freedom of movement under Article 19 1 of D read with Article 21. 19 freedom of speech and expression, 21 right to life and personal liberty. Correct. The court held that pedestrians have priority over motor vehicles on designated footpaths. This is correct. That is why the criticism was there for your Motor Vehicles Act. The court observed that remedies for failure to provide safe footpaths are available only under Motor Vehicle Act. Now look at this. It is not available only under Motor Vehicle Act, also through your legal and constitutional remedies alongside Motor Vehicle Act. So correct option is 1 and 2 only. Next topic is Center tightens FCRA rules for NGOs receiving foreign funds. Read. First, I'll tell you the background of your FCRA or Foreign Contribution Regulations Act. Now, this was initially brought about during your 1970s decade, specifically by your 1976. Why, if you see? So that we didn't want foreign money or foreign influence to affect India's sovereignty or security. That was the point of your emergency, right? So now FCRA has got few stricter rules with respect to foreign contributions coming into India. Okay, what are those as we will be seeing? Your Ministry of Home Affairs has notified the new amendment rules for FCRA, foreign contributions. It introduces stricter compliances for NGOs. NGOs means non-governmental organizations or non-profit organizations or charities. Okay. What have they brought about? Stricter compliance, conversion ban is reiterated, greater transparency. What do I mean by this? If you are an organization or an entity who receives foreign fund, you can receive it only for certain elements. Let's say you want to receive funds for religious work, you can do. But that money cannot be used for conversion of people to another religion. Understanding? And all this data should be in a transparent manner. What this is, let us get into detail. Before that, what is FCRA? Foreign Contribution Regulation Act. It is about internal security regulation, which means foreign contribution which comes into India, either for individuals, associations, NGOs or companies. If you see, FCRA was enacted during your emergency period of time. Then it was replaced in 2010. Now a lot of amendments has been done in 16, 18 and 20. The new amendments comes in 2026. Who is the nodal ministry of all this means? It is Ministry of Home Affairs. Now, what are the objectives of bringing these new rules or amendments? If you see, it is to protect the sovereignty of India and internal security, safeguard the public interest and prevent foreign influence in affecting any of this and ensure democratic integrity. Okay. Now, according to Article 19(1) of C, it is a fundamental right to form associations, but there are reasonable restrictions for sovereignty, integrity and public order. In the Newell Harper versus Union of India case, your judiciary held that FCRA is legally valid and the grounds, okay, as exceptions, sovereignty, integrity and public order is also valid. Okay, that is what they held. Next, in your Indian Social Action Forum versus Union of India, they said the objective of Foreign Contribution Regulation Act is valid and this has to balance both your national security as well as NGO freedom. Okay, so they told that let's say your MP, MLA, okay, ministers, they and all can't receive your foreign funding. Apart from that, organizations having specific goals, they can receive. So this is what they held. Now let's see what is it that we have in FCRA Act. See, first and foremost, any entity which wants to receive foreign funding has to be registered. First and foremost, it is not like you will receive funds and then you will register. No, you have to register yourself first. Okay, that one registration is valid for 5 years. You have to re-register before 6 months of expiry of the 5-year period. Where can you register? You can register in any one of these. Societies Act of 1860, Indian Trusts Act of 1882, Companies Act of 2013. Okay, in any of this you can register. And also the money that you are getting from the foreign contribution, it will be going only to the designated FCRA account and it will initially, the first you will receive is only in State Bank of India in the New Delhi main branch. And one more important thing is, let's say I am an entity who is registered under FCRA, I have got funding, I will at no point of time transfer this fund into any other entity, even though if that entity is also registered under FCRA or not. Okay. So who is prohibited from receiving the foreign contribution means election candidates, again to protect the sovereignty of India, MPs, MLAs, ministers, political parties, judges, government servants, employees of government owned corporations, again to make sure that they do not have a sway in the Indian interest, and publishers or editors or cartoonists of registered news media. Okay. What is the 2026 amendment rule stating means? See, whatever foreign funds you are getting, you can use it for worship. You can use it for religious education, heritage preservation, community kitchens, all of this. But you at any point of time cannot use this fund for proselytization or religious conversion. Explicitly they have told you can use the foreign fund for your worship, religious education, etc. But that does not mean your conversion. Religious propagation as a fundamental right, it is allowed. For example, Article 25, you have a right to propagate. Right to propagate does not mean conversion is a fundamental right. Okay, conversion is not a fundamental right. So according to your Rev. Stain Losses versus State of Madhya Pradesh in 1977 also, They tell Article 25 protects, profess, practice and propagate religion, spread the religion, but this does not include a right to conversion as a fundamental right. Okay, that same thing is reiterated now in the new rules. Also, any foreign national, let's say except PIOs, who are not eligible for FCRA registration, okay, and see president, secretary, treasurer, all of these people, if you see, if you are going to get foreign funds, you cannot get the second installment of the foreign funds until you utilize 75% of the previously given money. And on that, at least a minimum of 10 lakh rupees you have to spend on approved activities. Approved activities means, let's say I have opened an NGO for suicide prevention. Then I have to do something for that. Yes. Also, they have gone for enhanced transparency, such as mandated disclosure should be there of who is the donor in the official website, social media publications. All this is just to make sure that there is an enhanced level of transparency. Okay, let's see one possible question. Consider the following statements regarding the Foreign Contribution Regulation Act or FCRA Act of 2010. The Act is administered by Ministry of Home Affairs. It is the nodal agency. Correct. All foreign contributions must be first received in a designated FCRA account to the SBI in New Delhi main branch. Correct. The FCRA Amendment Act 2020 permits FCRA registered organizations to transfer foreign contribution to other FCRA registered NGOs. No, this is one specific thing we have told, that you cannot transfer the funds even if it is a FCRA registered. So, they cannot transfer the funds. The correct options are 1 and 2 only. The next topic is passport is a travel document and not a proof of citizenship. Okay. See, look at this. Your Ministry of External Affairs has given a clarification telling that passport is a document which is only meant for travel, and this does not explicitly claim or held that this is your citizenship status. Understanding? Citizenship comes under your union list. One person who can do anything with respect to citizenship, that is your parliament. Okay, one entity. Now, when they have told passport is just a mere travel document and not a proof of citizenship, then there arises, then is there one single document throughout, that is uniform throughout India to prove citizenship? Means no, that is also not there. Now, the debate that has come under this is based on your SIR controversy, and this has sparked the citizenship proof debate. First and foremost, let's discuss what is this SIR controversy. SIR stands for Special Intensive Revision. Can your election commission do SIR? Yes. What is this SIR? It is to remove your voter duplicates, okay, faulty entries, duplicitous entries. So it is more like a cleaning process. You are removing the duplicate votes. While doing this, many a times accidentally also data and name of people can get deleted. Yes, maybe they have moved somewhere. So because of this, if a person's name is not appearing in the electoral rolls, does it mean he or she is no longer a citizen? No, right? So this is what Supreme Court also clarified. Let's say if a person's name is not coming or is missing in the voter list, that doesn't mean that person is not a citizen. The proof of burden, whether the person is citizen or not, is now lying on the person to prove himself. And Election Commission of India can only do this process, but it cannot decide or determine citizenship status, because the data has to be sent to your Ministry of Home Affairs and not Election Commission, because Election Commission does not have the power to determine who a citizen is and who a citizen is not. Understanding? So, what is the main thing we can take away? Passport is not proof of citizenship. So, what is a passport then? It is just a travel document. So, this enables international travel for the passport holder, and this indicates nationality only in travel purposes from where this particular person is. But this alone cannot be used as a proof for citizenship. Then, what is the legal status of passport? In Menka Gandhi versus Union of India case, the passport confiscation under Article 21. See, we have this thing called right to movement. A right to movement within the territory of India is protected by Article 19. Right to movement outside territory of India is protected under Article 21. Okay, this became very strongly sure that of your Menka Gandhi case, passport is linked to your personal liberty and protected under Article 21. And your Passport Act of 1967 section 20 even tells that Union government can even issue passport to a non-citizen. So much so that in Madras High Court 2023, they allowed a stateless Sri Lankan refugee to apply for a passport. So technically, is he a citizen? No, right? So they are telling your passport cannot be conclusive proof of citizenship. Okay. Next. In Lal Babu Hussain versus Electoral Registration Officer 1995 case, the Supreme Court also held that your electoral rolls and citizen presumption, etc. Okay, inclusion of a person's name in the electoral roll is a presumption of a citizenship. But one more important thing you have to know is your citizenship, whatever you are acquiring, okay, it has to come from a particular source. What is that particular source here? That is your parliament, right? In Association for Democratic Reforms or ADR versus Election Commission of India, your Supreme Court upheld the validity of SIR, Special Intensive Revision. It told that there were many loopholes. We have plugged that through our suggestions. Based on what rights can your Election Commission conduct your SIR in the first place? through Article 324 and also Section 21 of 3 of Representation of People's Act of 1950. So SIR is considered as a valid election exercise, and that in no way will undermine your citizenship status, because Election Commission is not the right body or authority to do. So what can Election Commission do? It can conduct your citizenship inquiry for voter enrollment only. It cannot decide final citizenship status of any individual, because that is not the jurisdiction of Election Commission of India. It is only going to Ministry of Home Affairs. Finally, the law will be made by your Parliament. The act that decides this is your Indian Citizenship Act of 1955. So, deletion of your name from voter list does not automatically mean that you have lost the citizenship. Okay. What is the court directions for this? In case there is any names that has been left off or there is an issue, then that will be referred to Ministry of Home Affairs, and how it will be decided will be based on Citizenship Act of 1955. Understanding? Not your Election Commission, because that is not the jurisdictional authority for determining citizenship. Though India does not have a single uniform citizenship document, citizenship is all determined under Citizenship Act. What basis pe can you get citizenship, such as your birth certificate, nationality, documents, and the burden of proving whether you are the citizen is on the individual who is claiming the citizenship, according to your Sarbanand Sonwal versus Union of India case. So, according to your Citizenship Act of 1955, how and all can you acquire citizenship? Means you can acquire citizenship by birth. Okay. From 26 January 1950 to 1987, how we were granting citizenship means the parent nationality was irrelevant. Just the child born on Indian soil was given the citizenship. This is called as jus soli, that is citizenship given based on the soil rights. Then from 87 to 2004, we had a shift from your jus soli to jus sanguini, where we said mandatory one parent must be an Indian citizen. 2004 onwards, we said, we completely went towards jus sanguini. Whether the child is born on my soil or not, if the child has to get Indian citizenship, then one parent must be an Indian citizen and the other parent should not be an illegal immigrant. Okay, then only they can get citizenship by birth. Other modes of acquisition of citizenship is by descent, by registration, and by naturalization. What is by descent? This is when your children are born outside the Indian territory. In those cases, you have to mandatorily register the birth of child in Indian consulate within 1 year of birth. Next is by registration. Okay. By registration, either person of Indian origin, spouse of Indian citizen. Okay, so in these cases, they will give you a residence qualification that you have to reside in India for so and so years. Same is with respect to your naturalization. Compared to all the citizenship, your citizenship acquired by registration and naturalization, you will get a citizenship certificate. Okay, where the same is not issued for your by birth, okay, by descent and all these things. Next, what are the major amendments that is made into your Citizenship Act? If you see, in 2003, they restricted citizenship, wherein telling that illegal immigrants are barred from getting citizenship. 2019 they said the residency requirement, that is minimum amount of years you have to stay as not an illegal immigrant, they reduced it for certain specific minorities who have always faced religious persecution. Who are those? Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from your Pakistan, Bangladesh and Afghanistan. Okay, for them they reduced from your 7 years, 12 years to just 5 years. Okay, and they should have entered India on or before 31st December 2014. So what is your passport? It is just a travel document. Citizenship is a legal status. Understanding? Passport is not considered as a proof of citizenship. No. Consider the following statements regarding citizenship and passports in India. An Indian passport is conclusive legal proof of Indian citizenship. No, having an Indian passport does not mean you are an Indian citizen. Passport is no longer a let's say document for citizenship. Ordinary citizens acquiring citizenship by birth or descent are generally not issued a citizenship certificate. Yes, correct. By birth, by descent people do not get citizenship certificate. Only registration and naturalization. Election Commission of India can determine the final citizenship status of a person while revising electoral rolls. No, they cannot determine. They do not have that jurisdictional capacity. So correct option is 2 only. Next, the last topic, criminalization of politics in India. Why are we discussing this? See, your Rajya Sabha, which is also called as upper house or also called as House of Elders. In this particular house, there is a new report by your Association of Democratic Reforms and National Election Watch report has held that presently how many MPs are sitting in Rajya Sabha? On them, at least 31% of the sitting MPs have criminal cases lodged on them. And in that, 16% of them face serious criminal charges. Here, serious criminal charges means with respect to your heinous crimes, murder, okay, atrocities against women, these kind of things. So, this has reviewed the concerns about criminalization in politics, people with criminal background entering politics, people with huge amount of your black money, muscle power. These people are entering politics, and if these people are being put in the offices, then they will do things that will be beneficial for them or a particular section. That is the debate. So according to the report, 31% of Rajya Sabha MPs have criminal cases on them, okay, and at least 16% of them are facing serious criminal charges with respect to murder, attempt to murder, kidnapping, crimes against women. If you see state-wise share, your states like Telangana, Delhi, Maharashtra are having higher percentage of the cases. And also if you see the wealth concentration of Rajya Sabha, it is very high. Meaning, on an average if you see, okay, of all the MPs, 120.69 crore assets are there. A lot of billionaires are there in Rajya Sabha. At least 14% of the MPs are billionaires in Rajya Sabha. So this showcases the money power, muscle power in your politics. So criminal politician business nexus gets strengthened. Legislative integrity weakens because the quality of lawmaking reduces. They will be focusing only on their development. And House of Elders has been undermined because only money and muscle power is gaining over your merit. What does criminalization of politics means? Any person who enters the politics with a criminal background or pending criminal cases, or he is convicted, into elections, legislatures or public offices, that is called criminalization of offense. What does it do? It encourages corruption, public trust reduces. This also promotes money and muscle power. At the end of the day, it weakens democracy itself. So what causes your criminalization? That is, why are people with these records entering in the first place and being able to win? Winnable parties. Your political parties will offer party tickets in a very opaque manner. So they will only give seats to people who can win. Who can win? Anyone who has good amount of black money. Also make sure that your muscle power is used. Okay. So winnability is seen. The criminal, in fact, a survey even suggests a candidate with criminal record has 15% higher success of winning than a clean candidate who has only 4% of winning success. And also, winners just need plurality, first past the system, not the majority. So this is where they do caste and community mobilization, favoring influential candidates. Okay, so they use this money and muscle power to make sure they will get this. And another thing is, even though they have been, let's say, your RPA Act, etc., which tells that if a person is convicted for more than 2 years, he will be disqualified and all that. But conviction has to happen. But most of the times, these members the case only will be lodged on them, right? By the time it finishes, it is a slow judicial process, lot of pendency is there. So by the time a person is convicted, he would have already run for multiple terms. So even though section 8 of RP Act tells that you will be disqualified after you are convicted for more than 2 years, but this is not applicable for pending cases. So that is why all the cases are pending. And largely they will try to use identity politics in the name of caste, religion, okay? And the voters will lose the trust in the public institution, and wealthy candidates are given the party tickets because it is opaque functioning rather than grassroots level who have worked for the party. So what are the constitutional legal provisions? Article 19(1) of A. A right, Supreme Court has told that a right to information also means that right to know the contesting candidate ka background also. Representation of RP Act 1951 section 8 tells that a candidate can be disqualified if he has been convicted for more than 2 years, not for lodging the case, but he should be convicted. Okay, disqualification will continue during the imprisonment of the 2 years and 6 years after that release. Okay, but you are not disqualified if you have pending criminal cases. This is where the highest number comes in. Okay, and just framing of charges, because of our slow judicial let's say the backlogs we have, these people try to use this as a legal loophole. Next, in your 2002 Union of India versus ADR case, the Supreme Court told that the voters have a right to know, and mandatorily everyone has to disclose their criminal cases, assets, liabilities and education. In PUCL versus Union of India case, they said a right to know is a part of Article 19(1) of A, and they struck down Section 33B of RPA. What is Section 33B of RPA? The candidate need not share any of the information, okay, personal information, but this was struck down. And in K. Prabhakaran was, in this case, they said it's more like a guidelines. Those who break the law should not be the ones who make the law. In Lily Thomas versus Union of India case, they said if you are disqualified, that is for because of the conviction, you should be disqualified. Okay. In Manoj Narula versus Union of India case also, see, it is the discretion of the PM to pick whoever he wants as the Council of Minister, but it is preferred if he does not pick a person with serious allegations and charges. Okay. Next, Public Interest Foundation versus Union of India case, they told that only Parliament can legislate disqualification. Okay, and parties also must tell their about their candidates and backdrop before they showcase the candidates. Okay, and Ram Babu Singh Thakur case also, it was given for your election commission to make sure that they are properly following the disclosure of your disclosure compliance by the political parties. Many committees have also been there. Your Vohra committee of 1993, which told that you have to try to reduce the criminalization in politics. Dinesh Goswami committee also told that states should fund the election, so that point of time your money and muscle power of criminalization will not come in. Indrajit Gupta committee also recognized state funding for the elections. Now let's see a possible prelims question on this. Consider the following statements regarding criminalization of politics in India. Under the RPI Act of 1951, a candidate is disqualified from contesting elections immediately upon framing of criminal charges. No, upon framing, nothing will happen. Conviction has to happen. Okay, for more than 2 years. So, first statement is wrong. In Lily Thomas versus Union of India case, Supreme Court held that MPs and MLAs convicted and sentenced to imprisonment for 2 years or more stand immediately disqualified. Yes, this is correct. In Public Interest Foundation versus Union of India, Supreme Court directed political parties to publicize criminal antecedents of their candidates. Yes, this is also correct. So the correct options are 2 and 3 only. Okay. With this, we have come to the end of the topic. Any doubts? Online class, any doubts? We'll end the session.